Honorable scientists, distinguished guests, ladies and gentlemen, good afternoon. Welcome to the last session of the Beacons of Research Journey organized by the Council of the Hong Kong Laureate Forum, also known as HKLF. This is Patricia Young, and it's my pleasure hosting for you today. The Beacons of Research Journey serves as a prelude to the second Hong Kong Laureate Forum, a world-class academic exchange event scheduled for the 5th to the 8th of November this year. Before we dive into today's topic, let's review the insights shared in the first two sessions. During a discussion of interdisciplinary trends and innovations yesterday, our speakers shared how collaboration across disciplines can drive innovation, as well as emerging technologies and real-world applications. We covered fundamental topics this morning in navigating a career in research, as well as transitioning between career stages, how to set up collaboration, and how to secure funding. And we'll now move on to our session this afternoon, where we'll focus on tips for intellectual property in scientific research. The session will provide you with the tools you need to navigate the complexities of intellectual property in your research projects. Upon completion of all the presentations, there will be a panel discussion and a Q&A. We welcome questions from the audience, and ample time will also be reserved for networking and direct communications. And today we're very honored to have Mr. Hendrik Sin, Chairman of China Prosperity Capital, to be our guest of honor. Now let's welcome Mr. Sin on stage for an opening remarks.
Good afternoon, Professor Tong, Professor Low, and all distinguished guests here. Good afternoon. It is my great honor to be here today, and I would like to begin by expressing my deepest gratitude to Professor Tong for his invitation. Hong Kong Laureate Forum provides a remarkable platform for supporting youth development in Hong Kong and the international community by facilitating networking among young scientists globally. The two-day seminar of the Beacon of the Research Journey is the preliminary event for the Hong Kong Laureate Forum 2025, which will be held in November this year. It provides academia and young scientists with invaluable opportunities to expand their knowledge, network, and career prospects. By engaging with experts in their field, they gain exposures to cutting-edge research, innovative methodologies, and emerging trends that may not be covered in traditional academic settings. Today, let's discuss a bit about the power of intellectual properties, or IP. IP is the cornerstone of success. It plays a vital role in scientific research. Science and innovations are the engines of economic growth and society advancement. Every breakthrough, from life-saving medicines to cutting-edge technologies, start with an idea. But without IP protection, these ideas risk being lost, underutilized, or explode without benefits to their creators. Also, IP is more than just legal protection. It is a strategic tool that transforms research into real-world impact. Patents, copyrights, and trademarks ensure that innovators reap the rewards of their works, fostering further investment into R&D. More importantly, IP enables collaborations between academia and industry, turning laboratory discoveries into market-ready solutions that drive economic growth, create jobs, and improve lives. As a tech practitioners for centuries in multiple roles, including Hong Kong Deputy to the National People's Congress, the chairperson of the Committee of the $3 billion AI subsidy scheme, and the chairman of China Prosperity Capital Fund, where we are one of the top 100 Chinese VC, and we focus on disruptive innovations, and we invest heavily in Hong Kong universities' laboratory products. And I'm also a co-founder of a Hong Kong-listed company where we are one of the largest Chinese publisher of mobile games based upon IPs. I do think IP is very important to scientific research, and it helps to stimulate innovation. IP allows scientists to gain the recognition and financial benefits and encourage the most innovative company to invest, collaborate, and share their talents with the whole world while protecting their hard-earned achievements. China has emerged as a global leader in innovations with massive investment in R&D and a rapidly growing IP ecosystem. Hong Kong, with its world-class universities, strong legal framework, and positions as an international hub, serve as a bridge or a super connector between mainland China and the global market. Our unique strengths, including robust IP protection, access to funding, and the dynamic startup cultures, make this region an ideal place for young scientists to turn their ideas into reality. Hong Kong's unique positions as a global hub provides unparalleled access to international markets. Strong IP protections ensure your innovations are safeguarded as you expand your research beyond the city borders. A robust IP regime signals to the world that Hong Kong is serious about innovation. This attracts the best minds and much needed investment, fueling the growth of our innovation ecosystem. As we all know, Hong Kong uses a common law system renowned for its fairness and efficiency, providing a strong foundation for IP protection and enforcement. The Hong Kong government is actively promoting innovation and technology, offering various funding schemes and initiatives to support IP creation and commercialization. To young researchers in this hall, your ideas have the power to change the world. But to maximize the impact, you must think beyond the lab. View IP not as a legal formality, but also as a strategic asset, one that can attract investors, secure partnerships, and amplify the reach of your work. For young scientists of Hong Kong, you are the future of our innovation landscape. By understanding and leveraging the power of IP, you can turn your groundbreaking idea into reality, contribute to the advancement of science and technology, and shape the brighter future of Hong Kong and the world. So remember, your ideas is valuable, protect them, nurture them, and let them shine. Together, through science and strategic IP leadership, we can build brighter, smarter, healthier, and more prosperous world. Thank you very much.
Thank you, Mr. Sin. Please remain on stage for a group photo. And thank you for being here today. At this juncture, we would like to first invite the chairman of HKLF, Professor Tong, to join Mr. Sin on stage. And next, we'll be inviting our speakers to join us for this photo. First, please welcome Professor Dennis Low from the Chinese University of Hong Kong, also HKLF Council member. Next, may we invite Dr. Ricky Chiu, FACE Scientific International Limited. Mr. Kelvin Wong, the Hong Kong Polytechnic University, please welcome. And we also have Ms. Jennifer Che from Eagle IP. Let's smile for the camera at the front, just there at the center. I'm sure we can't wait to learn from our speakers today. Okay, one more photo. Thank you very much. Once again, please take your seats. Thank you. Thank you again for all your support to the HKLF and for being here today. And at this moment, we would like to have a photo of everybody joining us this afternoon. So may we have the photographer ready at this stage? And let's have your smiles ready as well. And smile for the camera there. All right. Lovely smiles, and be ready for the photo. 3, 2, 1, cheers! And we also have a video camera. If you could just wave to the camera, please. Yay! Thank you very much, everyone. Thank you. That's marvelous. Today, our 4 esteemed speakers will cover key topics related to intellectual property. They'll discuss the challenges and strategies with personal experience sharing, how to protect it in a global market, and share tips for patent applications in scientific research. Without further ado, please join me to welcome our first speaker, Professor Dennis Low, Vice-Chancellor and President Li Ka-shing Professor of Medicine at the Chinese University of Hong Kong. Let's welcome Professor Low. Professor Low will share with us on trials and tribulations in intellectual property protection, a personal experience. Professor Low, please.
Thank you. I'd like to thank Professor Timothy Tong for kindly inviting me to give this opportunity for me to talk a bit about my experience. with IP protection. So I'm a DNA scientist. I'm also a doctor. So my primary area of work is in prenatal testing. So basically, when a woman is pregnant, she'd like to know about the health of a baby, including the genetic health. And for many years, to do that, you need to take some fetal materials for testing. And this involves sticking a big needle into the uterus. But every time you do that, there's a risk you might harm the baby. So many years ago, I was thinking, is it possible I can do away with all of that, just to substitute that with a non-invasive blood test that can do on the blood of the mother. So I was thinking, is it possible that during pregnancy, the baby would release its DNA into the bloodstream of mother? So the question is, how do you know that this DNA is from a baby? So I thought, well, if the baby is a boy, then actually it will start to release Y chromosome DNA in the bloodstream. So I was thinking, we can take some blood, and then I was wondering, maybe actually when the DNA is leaking into mother's blood, it will float in this yellow fluid, which is plasma. So those are cell-free DNA. So we actually did this very simple experiment in which I take some blood from mother and then just boil it for a few minutes. And then I take a few drops of that material, and lo and behold, you can already see that there is a signal in some women, but no signal in others. And eventually we find that all of this have baby boys, and the rest have baby girls. So this is the first demonstration of present fetal DNA in maternal blood. And then we find that this DNA is present very early, from the 7 weeks of pregnancy onwards. Actually, by the 10 weeks of pregnancy, it reaches some 15%, which is very high. And then after delivery, baby is gone within 2 hours. So thinking, well, is it possible we can use this technology for prenatal testing? And the number one reason why pregnant women go for prenatal testing is because they're worried that baby might have chromosome disorders like Down syndrome. So basically, normally we have 23 pairs of chromosomes, and the chromosomes are the carriers of DNA. And they're from the big one, which is number 1, all the way to a very small one. And actually, each of those numbers will have 1 pair. But for people with Down syndrome, instead of having 2, chromosome 21, they have 3. And so, for example, if you don't want to test whether a baby has Down syndrome, we conventionally will take a cell from a baby through amniocentesis, for example, and then you probe the cell, and then see how many signals it has on chromosome 21. So here, you see 3 red dots, so which is that the baby has Down syndrome, the 3 chromosome 21. But however, for my field, it's a bit difficult because I'm actually looking at DNA outside cell. So how can you actually look at a signal outside the cell and then be able to deduce how many chromosomes is inside the cell? It's almost like in this room, right? By looking at how many people outside this room, how can you know exactly, let's say 50 or 60 people inside the room? It's pretty challenging. So we actually thought about this for about 10 years. And interestingly, in the end, we actually managed to have an answer. And the answer is like this. So imagine you have a wallet, and you can have different amount of money per day. So let's say on one day you have 4 coins, and some other days you might only have 3. And I want to know how many coins you've got today. And so one way, of course, is ask you to take out your wallet, right? Another way is to actually weight you. Now, theoretically, the day when you're richer, you might be a little bit heavier. It's just like that. But of course, your balance has to be super accurate, because imagine if you are, say, 60 kilograms, having just 1 extra coin, you'll be 60.01 kilogram. So your balance has to be super precise. So what that means is that I have to develop a way to measure the DNA amount. Now, conventionally, people measure DNA using method like PCR. You know, when you have COVID testing, that is a PCR test. So PCR is basically a way to amplify DNA exponentially. And because the exponential amplification is normally very good if I'm telling, say, 100 copies from 200 copies from 400 copies. But it's not so good if I'm trying to measure 100 copies from, say, 105 copies. It's very difficult. So I was thinking, is it possible I can improve the precision of PCR? Now, conventionally, if I test PCR, let's say I have a test tube, and you test everything in there, and most of the stuff is from mother, let's say the red signal. And every now and then you have a fetal DNA molecule, which is in yellow. So the problem is that when you do conventional PCR testing, the mother signal is going to overwhelm the fetal signal. So it's not very accurate. But another way to do that is instead of testing everything together, I can distribute it into many, many reaction wells so that one well will only have one molecule. And in this sort of situation, the baby molecule can be analyzed separately from others. And this method, the good thing is that you can be as precise as you want just by increasing the number of wells that you do. So we did this in 2007 and actually managed for the first time to non-invasively detect a Down syndrome baby. But interestingly, about a few weeks after we published the paper, another group published another paper which is exactly the same thing. So we use this digital PCR method. You can see they use the same. And also surprisingly, the two papers were submitted on the same day, which is amazing, right? So it shows you almost like whenever you have an idea, somebody else across the world somewhere will be thinking. And the reason is because as our technology is maturing, we actually suddenly have access to things that we don't have before, and suddenly people are thinking the same way. So that's why it's important to protect your intellectual property. But however, this PCR method has some problem because when you do PCR, you have to design primers to say which gene you're going to detect. But the problem is that on chromosome 21, there's about 150 genes. So normally, when I use this first generation PCR-based method, I can only look at one of the 150. So you're throwing a lot of useful information away. So I was thinking, is it possible I can develop a method which allowed me to measure everything? So I was thinking, is it possible I can, say, randomly sequence DNA molecules? So let's say in the blood, there are millions of DNA molecules. I randomly sequence many of them. And then because I know the human genome sequence, I can map each of the molecule to the chromosome from which it comes from. And then below, statistically, I can measure whether the chromosome ratio, which one is normal, which one is a little bit increased, like chromosome 21. So in the end, but the problem is that you want to do that, you need a machine, a new DNA sequencer. This machine, at that time, around 2008, will cost you 4 million Hong Kong dollars. But strangely, at that time, the Hong Kong UGC, University Grants Committee, has a funny rule. It says that if you want to buy an expensive machine, believe it or not, every university has to agree with you. So CU want to buy something, but PolyU has to agree, Hong Kong U has to agree, everyone. But of course, although we're friends, but sometimes we compete as well, right? So when you are competing with your friend will say, okay, maybe I should delay you a little bit. So in the end, the project was delayed for 10 months. And I was thinking, wow, I can't really wait for that delay. So in the end, I give a call to this guy. He was the CEO of a NASDAQ-listed company in the US called Sequenom. And I said, well, I have this problem. Can you help me? And within 5 minutes, he said, no problem. 4 million Hong Kong dollars, nothing. So we have the machine, and we do it. And then we find that this technology works very well. You can see here, the green signal is Down syndrome male baby, and red one is Down syndrome female baby. The signal is very high. And compared with the normal babies, I can separate them 100% accuracy. And then we published this paper, 2008, 1 year later. But surprisingly, actually, within a few weeks of this paper, the other guys published the paper as well. And can see almost exactly the same by sequencing method, right? And then I start to wonder, who is this guy? So I find that this guy is actually a guy called Steve Quick. He's from Stanford. He's a bio engineer. And actually, incidentally, we actually went to the same university. I was at Oxford. I graduated in 94, and it happens he also graduated in the same year. So very, very interesting. So anyway, so now we have, yet the competitors still here, right? So they compete on the PCR and they compete on sequencing. And then, of course, the question now, whether this technique is good enough, we need to do a clinical trial. So I spent the next 3 years doing this and find a method to be super good. So this is Down syndrome, and this is normal. The accuracy is 99.7%. So he thinks that it is ready, so I want to push it out. But of course, to transfer the technology, the company will ask you, do you have patents? Now, so we have been very diligently filing patents for the last 20-odd years. But initially, I wasn't very experienced. I remember, actually, we have the very first patent in this field. And actually, that patent we licensed to a company in the UK. And that company didn't realize the significance of that. They just sit on it. And then a few years later, they thought it was rubbish. And they gave it back to the university free of charge. But that, of course, is a very big mistake to them because this patent turned out to be later on to be very, very valuable. And of course, but this bit of the story tells you that for the young people in the audience, if you have a new invention, my recommendation is you go to start your own company rather than licensing to other people and waiting for those guys to commercialize for you. It's always best to have control yourself. And so now, with a patent coming back to me, so we need to find another interested partner. So in one of the conferences, I met this gentleman who was the chief scientific officer of this company called Sequenom. And he's a National Academy member. And so we start talking and then collaborating. And eventually, Sequenom licensed our technology. But you can imagine now in Stanford, of course, they have many experience in this area. So Steve Quick actually licensed the technology to Verinata, which was then bought by a company called Illumina for about 600 million US. And although not only then, but at the same time, many other people start copying this technology and they start to launch their product. So as a result, there's a series of lawsuits fighting in this area. Now, so one of the things, what they try to do is because we have the very first patent, the 97 patent, talking about fetal DNA maternal plasma. So this thing is called a 540 patent. So people start to attack this patent. So why? Because now you can see that this patent is basically talking about a method to detect the fetal DNA by using a PCR system to detect something which the baby has inherited from the father, like the Y chromosome. And then the problem is that how do they attack? They attack by using something called 101. So what is 101? So 101 is basically talk about patent eligibility. So what things are eligible to be patented? And as it turns out, if you are talking about laws of nature or abstract thinking, then you cannot file a patent. Just like you see the sun, right? It's a natural phenomenon. You cannot patent the sun. So what those people are arguing is fetal DNA in maternal blood is a natural phenomenon, so you cannot patent it. But of course, you know that is not true, right? Because I'm not patenting fetal DNA in maternal plasma. I'm talking about a method which require amplifying by using PCR. And of course, all of this are artificial processes. It's not natural phenomena. But unfortunately, sometimes in life, when you're born, when you're working is important. For us, it's unlucky because at that time, the US Supreme Court just had one case, which is a case concerning genetic sequence pattern, the BRCA1 gene, BRCA1, the breast cancer gene, you probably have heard, right? Because this patent was previously owned by a company called Myriad Genetics. But then some people start to say, well, maybe the DNA sequence is a natural phenomenon, so you should not have patents, right? So as it turned out, Myriad lost. And so at that time, the Supreme Court and the court in the US is very against this type of patent. So in the end, they actually ruled that our first patent is not valid. And at that time, we actually have a lot of support from various people. For example, some people even say that this technology, by having this ruling, they basically is against patenting molecular diagnostics. Because imagine, you were trying to develop a test for, say, COVID virus. You know, the virus, of course, is a natural phenomenon, but the test is artificial. But if you're not allowed this, then it's very difficult to patent anything. But luckily, for patent, you also know that it's like you are trying to build a defense against some enemy. So usually, you don't have one level of defense, you have multiple wars. So for us, even though in the US we lost this first patent, we still have many others. And one of the important one is this one, which is based on randomly sequencing of plasma, which we published in 2008. But of course, you also remember that we have this competitor from Stanford working in the same area. So the question is, what happens about a patent there? So remember, both the Stanford guy and me start working on PCR, and then we move to sequencing. So as it turned out, the Stanford person first filed a patent in this time. And then for me, I filed it a little bit later. But interestingly, in my later filing, I already thought that the sequencing would probably work. So in my patent filing, I include both sequencing and PCR. And then after you file a patent, there's a period of 18 months where nobody knows because you don't publish it, right? So the other guys from Stanford didn't know about this. So they filed their patent at that point. Okay? So that's that. So in the end, basically, then there was a series of lawsuits. So you can imagine to decide who is the first one. So how do you know who is the first one, right? Of course, one way to say who is the first one to file a patent. Now, this is a rule for most parts of the world. But interesting, in the US, before 2012, they talk about who is the first one to invent. And that is a bit difficult, right? For example, like you may be talking to your friend last night in dinner, and you invent something. And then your competitor will invent it this morning when he or she is having breakfast. But the problem is that how do you prove that? I mean, you have to be having dinner, and then you write something on your napkins, and then you prove that. So it's very difficult. So it's very expensive things. So this type of lawsuit is called interference. So in the end, there are 4 interference lawsuits between Stanford and us. And actually, we won 3 of them, and they won 1. So as a result, so those guys have to pay us $50 million US, and then we decide to pool all the patents. So in that patent pool now, we probably have about 1,000 patents. And this is actually quite a good deal, because even if one patent in that pool survives, we still collect money. So this patent pool now actually helps CUHK probably contribute to 85% of the patent income of CUHK. So our team is basically free of salary, so to speak. So anyway, so this test has been used 100 million times now. Yeah. So you can imagine in Hong Kong, each test is about 5,000 Hong Kong dollars. But anyway, now, so normally you think, well, that is finished, right? Everybody's very happy. But unfortunately, under the water, there's still some ripple. So who is not happy? Now, of course, it's our friend in Stanford, so they're not happy because they think, well, there's no way, right, that we have this losing to this Chinese group. So what happened is this. So they continue to fight, so which is very strange. Now, because imagine our original patent and their Stanford patent are now under one company. It's almost like you have a shop, you're selling crystal glass, right? So they display very beautiful. But now, if they continue to fight, sooner or later, some of those glass will broken up, right? So it's bad for business. So anyway, in the end, it fights for another few years until 2019. And eventually, we won. And this is basically the verdict. So they say that the Stanford team tried to actually do this, so after we've done this. And they actually copy our claims. And so basically, inside the Stanford patent, they didn't have actually the written support on this. So I think if you file patent, you know that you've got to demonstrate to the patent examiners that you do possess the knowledge at the time of filing. So anyway, so in the end, so we won, but it's already very expensive. Actually, our licensee actually spent about $100 million US on defending all this patent, which is very expensive. So anyway, so nonetheless, in this exercise, I started to think, no, all of this is kind of a little bit like butterfly effect because of some small things which caused dragging on for about 10 years. And what is that small thing? The small thing is that I told you just now, at that time, the UGC have this rule that you need all the university to approve you. Because of that, I delayed 8 months, right? Just because of that, I have to fight 10 years of patent, you know? So this is something to think about. But how about Hong Kong? So for Hong Kong, I was encouraged by the past commissioner of the Innovation Technology Commission to start a company myself called XLOM. XLOM stands for Extracellular Genome. And the Chinese name is Nga Si Lang. Nga Si is like Man Yan Nga Si, right? We thought we are academician, and even us can do something. Okay? So in the end, actually, XLOM become the market leader of non-invasive prenatal tests in Hong Kong. But if you're successful, people start to copy your stuff. So in the end, somebody copied our technology, so we have to start some lawsuits in Hong Kong again, right? But one problem of Hong Kong fighting lawsuit is that very few people actually fight patent lawsuits in Hong Kong, right? If you ask a patent lawyer, you know. So the courts and even the lawyers are not very experienced. It's very expensive. So in the end, we fought for about 4 days. And it cost me 13 million Hong Kong dollars. And so anyway, so in the end, it was settled, and then to our advantage. Now, another issue that we have to think about is that we become a market leader in this field in Hong Kong. And we've wondered, well, can I benefit the mainland pregnant women? But the problem is that we have some issues. Because we cannot easily transfer samples and DNA data across the border. And secondly, as Hong Kong citizens, we cannot directly open genetic testing facility on the mainland. And also, even though we have a patent in Hong Kong, you cannot readily register it back in mainland China. Although this patent eventually was granted. That would be a story for another day. Actually, our main patent has just been granted by the Supreme Court in mainland China, has just said that that patent is worthy of protection. So anyway, so I hope that in the future with the loop, the He Tao, that we will be able to overcome some of the limitations I talked about just now. So finally, in conclusion, I believe there's a synergy between academic research and commercialization, and IP protection is essential to the technology ecosystem. And you can also see that some of the policy inefficiencies might have long-term implications. And secondly, streamlining this policy is essential to develop Hong Kong as a biotechnology hub. So thank you very much.
Thank you very much, Professor Lo, for sharing your personal experience. Very intriguing. Thank you. And we want to learn more from you later at the panel session. Well, the next speaker is going to tell us his tips on intellectual property in scientific research. Now, please welcome Dr. Ricky Chiu, Chairman and Chief Executive Officer at Phase Scientific International Limited. Welcome again, Dr. Chiu.
Hello, everyone. So, yeah, thank you again for the invitation to share some experience that we have. But coming from the industry, coming actually from a startup, from a small company, right? I think for those of you that were around this morning, you understand my journey going from a scientist, from a PhD student to be an entrepreneur. And I think IP, honestly, is one of the first things that I got to learn a lot about. And I think because we are standing in the shoulder of giants like Professor Dennis Lo, there are a lot of stories, there are a lot of litigation, there are a lot of drama regarding patents, regarding litigation. And that's why I do believe that we have the benefit of learning from those lessons, and we are able to be more preemptive about the protections and avoid a lot of the incidents or drama that follows. But I think let me give you a little bit more of the background for myself. So now our company today spans in 3 different markets, both in Hong Kong, China, and the US. As I mentioned this morning, we originate in the US, but then in 2018, I moved the headquarters to Hong Kong. And after the pandemic, we expand the business to China as well. So the reason I emphasize this is because as a small company, as a technology that are not as sexy and valuable as Professor Dennis Lo patents, you have to really be cost effective and understand how you do your protection, okay? So I think, the patent to a scientist or someone that want to form a startup, this is really your first product. How do you define product is something that you create that can in exchange for money, okay? The way that I view patent originally is exactly a product. It's the earliest type of product. This product is kind of like a raw material that you can use that to generate, let it become more mature in the process, and ultimately to be a real product. But a patent itself is something of your idea that you can generate very quickly, and then, but at the same time, you can also protect it, and it is valuable enough, then someone would be willing to exchange money or able to make collaboration with you simply based on the idea that you have. And that's why able to productize or able to protect the idea, and of course the data that able to come follow to support your idea is definitely patent worthy. But again, as a small business, as a small company, our budget is limited. So what you have to do is making sure that you have the best buck for what you invest. Of course, you have to invest in your patent because, again, this is your product. They have the potential to commercialize. You can use that as a currency. You can go in exchange for collaboration, in exchange for money, in collaborations, right? But we file patents based on where we operate, okay? And while I guess one point for us that we operate both in the 2 largest markets in the world, and both in China and the US. So yes, there are some cost saving in Argentina. We make a decision not to file patent in Argentina. But although even though we don't have activity right now in Europe, but should I go into EU to protect my patent in the EU? Probably, right? So I think this is very important to have consultant and advisors and mentor that I mentioned this morning, someone that have really done this before to give you the advice and understand your situation and able to give you the best advice. And honestly, I think this is the best advice I'm able to give today, because everything that I learned about IP, learned from the predecessors, learned from my patent lawyers. So after you understand where you're going to run your business, then you need to look at your product portfolio. Like for us to a little bit go further along, now that we have different categories of products, I think most people know that we have the RATs product, right? We have the RATs, but at the same time, a lot of people doesn't understand that we actually have a whole clinical laboratory, and we have a combination of different clinical assays that we developed using our core technologies, and then we use our clinical lab in Hong Kong and China and the US to provide services. So besides giving our products, we are also producing services as a way in exchange for people's money in doing business. So how can we protect all these, right? It also means that before you're trying to do the commercialization, able to have certain protections in investing in patent is very crucial. So this is the core technology that we have. For some of you that were here this morning, I'm going to repeat myself again, but what we have here is a sample preparation technologies, right? In order to improve the accuracy, the sensitivity of a diagnostic, our core technology is to pre-concentrate the target of interest prior to the downstream detection. And the way that we discover this is originally we do that on rapid diagnostic, right? Because as you know this morning, my very first job is working in an RAT business. So that's why my PhD thesis is largely focusing on this sample preparation technology applying on RATs, right? In fact, because that was my PhD thesis, UCLA owned the patents. Okay, so now when I decide to form the startup, the very first thing is I need to go negotiate with UCLA. I think good things about UCLA is it has also been quite mature in terms of the ecosystem on entrepreneurship. So I think the tech transfer office is also very approachable and friendly, and at the get-go of the negotiation, because we have heard so many drama prior to us, right? We are able to get exclusive global licensing rights of the technology, of the patent that I generate from my PhD thesis. And with that foundation, that really gives me the confidence to move on to talk to the investor, to apply for grants, to go to a pitch like this, to explain the technology to most people, right? But those patents that developed at UCLA is kind of the first stage of my startup, or only half of what our technology can be applied, which is applying to the rapid diagnostics, to the RATs. Right? As I mentioned this morning, inspired by Professor Dennis Lowe, I recognize that our technology can also be applied to molecular assays, right? And after we demonstrate that we're able to do that, and actually before we actually fully demonstrate that we can do that, we identify a provisional patent to ensuring that our technology is being covered, also being protected for our application to extend it into other areas. And that's why right now, if you look at our IP portfolios, we have some IPs that are owned by UCLA, and then we are also having some that are owned by FACE ourselves, right? But I think a lot of inventors would be very hung up into the ownership of the patent, right? Okay? But I think if you put on the head of a businessman, okay, I think you come from a different perspective. You need to understand, as an owner owning the patent, of course, this is your baby. You should own it, and you should be proud about that, right? But as a business, the things that you care the most is the ability to operate the business sustainably. So now the key is, does that matter that I actually own the patent? Like, for example, the UCLA patent, although I invented them, but because I am so-called a UCLA student, UCLA owns the patent, right? All I can do is license it out. But I think that's why if you're able to get significant ownership, well, the licensing protections from UCLA, then maybe it's okay that you don't fully own the patent. So I think this may apply to a lot of the audience today because I think we are mostly students here. Honestly, your patent do owned by your universities. However, I do think the regulations and the rules in Hong Kong are improving significantly, where the inventor would have a bigger stake in the benefits of the patent. But I think this is a very first lesson that we learn is that before you even start doing a business, making sure you have this currency with you, which is the patent protection. Investor look very seriously into the patent that you have. Well, because that is the true and single one differentiation that you have. For an entrepreneur like me that I have no prior experience, I have no network, I have no rich fathers that give me a lot of money, right? You have to go ask for government for money, you have to go ask for investors for money. Why would they believe in you? Okay, the patent itself present a significant differentiation why you are able to do something that someone else cannot, and you have the right to protect you against that. So that's why I really see my early patents as my first products, and I want to invest in making sure that I can protect this safely because it itself is able to be a currency for me in exchange for collaboration and again for fundings. Okay. All right, so I think I'm repeating myself here. I think the IP is very important, especially for biotech companies. It can use for partnership, it can use for licensing, it can use for M&A activities. Very often when we talk to the partners that want to work together or they want to buy your company or buy your technology, the first thing to look at is what patent do you have? Because everyone trying to go for the least resistant, right? If they turn out that the cost of copying you is cheaper, they may copy you. But then if they find out they can simply pay you with a reasonable fee without breaking any laws and being a decent person, they can simply licensing your patent, well, they would probably choose to do that with you and negotiate with you and collaborate with you. So that's why actually having some form of protection is very important. But you got to understand at the company at your stage what kind of levels of protection that you want. But I think this is the beauty that, for a lot of us that we got our first invention coming out of the university. The university does give you certain protection and certain lawyers for you to get things going. Side note, I think I want to share my first patent experience from UCLA, because UCLA is a public school and it's known for very cautious, cost-conscious on everything. So actually, we have it's a well-known fact from our department that the patent lawyer that UCLA chose to use are very, mediocre, right? And that's why. But the thing is, if I do not form my own startup, I don't have my own source of funding, or I do not have at least the intention of trying to take this patent out, then UCLA would have all the say in determining, which lawyer to use and under what budget they have to use. Because honestly, universities file thousands of patents a year. They can't simply use the best lawyer and the most expensive lawyer as possible, right? But since I gave the intent to UCLA that I want to found a company, and yes, I don't have money now, but I would have in the future, but at least this patent, I do want to have an attorney of my choice to file the patent. I don't understand how that works in Hong Kong, but at least that is my experience in the US, that I do have to say to dictate, which patent lawyer that we use, and we use a lawyer that we are very happy about. And as I would mention later on, the patent lawyer do matters. And I also want to point out something, because I know Professor Dennis Low is speaking before me, so I want to talk about something that is quite different, which from a company perspective, besides filing patents, there is another method that, at least for my company, that we use very actively to protect our intellectual property that is in trade secret. Okay? There are a lot of things that may not deem appropriate to file for patent, because the essence of the patent is to tell the world exactly everything that you have so that people can reproduce that. But then in exchange, they give you a certain exclusive period of practicing that. Okay? Now, for my technology, as I explained, that we are able to have this, a formula of chemicals that are able to pre-concentrate the target in the samples. Our formula changed a lot. And honestly, our formula update even faster than an iPhone, right? I mean, for each year, we may have a couple iterations of something that we think is better than the previous generation. Now, to form a patent on each of these iterations of the formula may not make perfect sense because, well, first, they are too expensive. B, we're going to expose our entire formula to the entire world. It is so easy for someone to look at that and get inspired and start, catching up faster than you do. I mean, at the end of the day, we are a small company with handful of researchers. Any bigger company can have 10 times, 100 times of our researcher. If they esteem indeed that what we have is interesting, they can put 10 times more resource and get way ahead of us. So I think we do have to understand where we are coming from and how can we best protect ourselves. And there is a very good way to do that, at least in our situation, which is called the trade secret. So how trade secret works is, the most common examples everyone talk about Coca-Cola, right? I mean, Coca-Cola still kept, the formula still kept under trade secret. What it does is you disclose to the world that you do have a trade secret, you put that formula in some kind of safe, okay? But then how do you manage that? We also learn a lot from our patent lawyers that, so basically, there are a couple of practices. The essential part is compartmentalize, okay? So how many people in my company actually knows the entire formula? Okay, who does knows the entire formula? It itself is a trade secret, okay? And at the same time, we do have R&D, we do have productions, we do need someone that actually need to buy the chemicals of our formulas from the vendors. But then the people that purchase the chemical and the one that do the research, they are a different group of people. So unless they all group together and trying to share everything, it's less likely for them to re-engineer the entire formula, okay? Now, the other way of us, how can we separate the information is, so for the production people, when they produce the formula, you need someone to procure the chemical. Again, they would know exactly what chemical that you use. But at the same time, for those that are actually in the factory to scoop the powder from the chemical, they would know the quantity of the formula that were being used. So there are a lot of information that you can segregate them out and give them into different individuals in your company so that your entire trade secret is only being known to a very few individuals, but everyone would only need a very small sections of your formula. And by using that, we believe that we are able to protect our patents in a more cost-effective way. But actually, honestly, I think it's more suitable to the company in our situation and the line of business that we are doing. So this is trade secret management. And I think when you file enough patents, you can see that I have a lot of patents, okay? And the most important patents, honestly, is single digit. There's only a handful of patents that are so important, right? But just like Professor Dennis Lowe said, you want to build a moat, you want to build a castle around your patent. And that is exactly what we do. So that's why doing patents is not cheap, and it requires a lot of strategies. And basically, you can have very, very ironclad protections, and you can have some protection with holes that you take certain risk. That's why as a business, you have a choice. You want someone that really dedicated. You want some very trustable advisor to give you advice. But towards the fundraising round, right, when you are doing your Series A fundraising, the investor would, of course, look at your patent as a tech company and look at it to a certain degree. But I think as your series go further, go to Series B, Series C, even when you go IPO, then they do more due diligence into your patent. And at some point, they will do something called the FTO, the freedom to operate. Not only that you need to have patent, they also need to making sure that when you actually be famous, when your product actually being successful, is there someone else going to go out there to sue you? Because not every technology and company were as famous as Professor Dennis Lowe, that the moment that you publish a paper, everyone would know this is the one, right? And people want to get fight immediately. In a way, this is a lucky thing because you may know that until 5 years, 10 years from now, that when your things go out there, when you become famous, and then someone trying to kill you, and then you lose. that is actually, to me, it would be more devastating, to say the least. So I think that's why at times you do want to do freedom to operate, right? But I think any responsible lawyer would tell you if FTO is a black hole, right? You can spend millions and millions of dollars to do it, you may never get the right answer. So again, I think it's going back to the company at your state, what budget that you do have, they're willing to spend, what kind of dollar, what kind of bandwidth, what kind of man hours to do the FTO. I want to emphasize that if you think yourself as a business, you have to be responsible for your business, not an inventor, not a scientist. You can only have a set budget to spend to protect what you can do, because you can't spend 50% of your budget simply protecting a patent, then you won't have enough budget to do the rest, right? So how do you put in the right amount of budget to do what you can at your stage? Often require also to look internally where you are, who you are, what do you want to do. Okay, so I think for summary, strategy for startup and growing companies. First, again, despite everything I said, being cost sensitive and all that, doing an IP is a must. As a tech company, if you do have a unique technology, the first thing you want to do is you must want to protect it. And therefore, start thinking and train yourself to think about IP, because I think this is a basic well-known fact. Before your publication, before you disclose anything publicly, you do want to protect it. So at the very least, file an inventional disclosure, have the provisional patents, and then when it goes to the national phase where the money start kicking in, then you can hone down your patent strategies. But I think any of these with reasonable patent lawyers would be able to educate you, in the very beginning. And the second part is choosing the right law firm, right? Just like the budget that you have, you can always get the star patents, right? But which could be very expensive. But depends on the stage. You want to select one that are willing to work with you, right? And with that, we are very happy in Hong Kong to work with Jennifer, right? And that I think is a very good match, because like if you go to the very big, first in Hong Kong, you don't have a lot of choice, okay? But at the same time, if you are nobody and you want to go to a very big firm, what do you expect? They probably have some interns or some lower level lawyers that are trying to help you. And very often, yes, you got the brand name, which may help for the investor, but if any savvy investor will also understand that, hey, you going to the brand name may not be the best choice that you have. So you want to find, lawyers that willing to work with you, spend time with you. But more importantly, you want to select a lawyer that really understand your field, right? I mean, in our biotech, in the bioscience, they are so vast, right? They are microfluidics, they are diagnostic, they are molecular, they are immunoassay guy, right? Simply, you really want to find a patent lawyer that does have certain background information in your prospective area that you can trust, that they believe, they understand your science, and they can come up with the best strategy to do you. That's why, choosing an IP firm, to me, is more than anything to finding the right partner and with the right kind of budget to do certain things. And lastly, if you do running an R&D team with your company, well, at least for my experience in Hong Kong, because we don't have a lot of mature industry, most of our scientists are coming directly from university, right? And many people are participating in the patent, in the technology developments, and they do think, to us, this is more of employee benefit almost, or a prestige, right? To get on publication and to get on inventors of the patent. But at the same time, it is very important for the management or for the founders to explain the whole concept of the patent and explain it to them. We can't simply, for the sake of filing patent or simply to award your efforts on research, to file patents, right? Patents are not cheap. Patents need to maintain, and patents, do come with a cost. They require a larger scale strategies, right? So we do need to educate our scientists about that. We can put you on publication, no problem. It's free, right? But then putting you on patents or filing unnecessary patents would hurt the company in the long run. So I just want to emphasize a lot from a business perspective on IPs. So thank you so much for your time.
Thank you very much, Dr. Chiu, for sharing your tips with us. Very, very important and truly inspiring to know about these knowledge, and that will actually help you all to save maybe millions of dollars if you're going to have very important scientific innovations in the future. Well, next we are going to have Mr. Kelvin Wong, Director of Knowledge Transfer and Entrepreneurship Office of the Hong Kong Polytechnic University, to share from his perspective. Please welcome Mr. Wong.
Good afternoon, Professor Tong. Good afternoon, Professor Low, so all the guests. So I'm very beyond here to share my experience in IP. So having two previous speakers actually sharing all the IP experience. So I think that would be also interesting for the audience because I only joined PolyU about 6 years ago. Before that, I came from industry. I personally, actually, I was the inventor, over 200 patents registered. So I in charge of the patent in the business perspective, strategic way perspective. So here I would like to share, how can I bring all the industry perspective to file patent in the universities. So I think all of you understand what is patent. So the IP. So actually the IP is a biggest group of the patents, and also have including many different ways. So if you have a patent, you file then you have a monopoly right and doing business. Of course, you can also to attract the investors, and also you can register. You can, if you own the patents, you can do transactions, and also I think one of the most asked questions is whether I can use the other people's patents to do my research. Of course, if this is not a commercial activities, and also you can do it in a private way, and experienced persons that you can find, so you don't infringe anyone's patents. So what are the IPs? Actually, IPs are in many different ways. I think the speakers, they also mentioned of the patents, usually about the inventions and process, but also sometimes the trademark is also very variable. So especially when you're doing drugs, your products, once you got your name very famous, the trademark is very variable. And also, I always remind the researcher or startups, before you start your own business, before you get famous, you should file your trademark first in different jurisdictions and different class. And copyrights, of course, you have your papers, then you don't need to, to do a registration, but it's automatically you have a patent right. Trade secrets, I think Ricky also mentioned already. If you do a product, you have a design protections to avoid, someone may 100% copy your products, and also geographical indications. That is more for association. So these are the IP. So we're talking about IP, so actually it has different types. Okay, so I think this is one of the most important statements I learned about 20 years ago when I first, to associate with patents. So if you want to file the patent, we have to consider that you have to disclose. So patent protection, have a legal protection. The first thing you need to disclose. So 用公開去換取個保護. If you don't want to disclose, you don't have a legal protections. So this statement also echo that what we say patent or trade secret. If something is very easy by decided around by the people, then, or if something is very hard to prove the third party infringe our patents, the better you don't disclose. If you don't disclose, then you don't have a legal protections. So, and the trade secret and know-how, I think Ricky also mentioned already, so I don't need to mention too much, I think. But also I think I supplement a little bit, whether this is why I said, whether you can prove the other people to infringe your patent. So I had the experience in Sweden. Before universities, I working in a robotic companies. So we sold products to Sweden, and they sue you. They say you infringe their technologies or products. So you have to prove, and it's sometimes the thing is very hard, especially like chemical formulas, the algorithm and chipset. It's very hard to prove that the other people to infringe you. So that is a very important point. First of all, we will remind the researcher whether you really want to file the patents, or what the point you need to extract out from your invention, what should be filed patent and what should not be filed patent. And of course, so the patent and know-how, this is always a very good discussions, and we have to consider that the nature of the inventions and the duration of the commercial value. So whether that is very quick, that would be have a next generation, and the cost of the complexities and the strategic business consideration, whether you want to file patents not only for commercialization but for MMA and also for to attract investor. And I think this also is very easy to mix up for the academic colleagues. You own the patents, or you are you are the inventor of the patent. So whether you have the ownership. So I think just like Ricky said, and by default, all the research conducted by the researchers automatically belongs to the university because this is underemployment. But however, what about the students? The students say, I thought about this idea. It has nothing to do with the universities. I should own the IP. So we should always understand this. This is underemployment. It's clear whether this is a normal duty, assigned a task, and an expected reasonable result. For the professor will argue with me, say, oh, I thought the idea I generated when I'm taking a bath at home. It's not a working hours, so why the IP belongs to the universities? So that is the reason, use substantial resources. So these are the main points that we have to be careful. And one day, if you have your own startups, you need to sign the employment contract with your staff. That regulation will be governed to say who own the IP ownership. And of course, if you are the owner of the IP, you have the right, you have to grant the license, you can make the products, and also to have secure the court orders to sue someone if they infringe you and receive the compensations. And collaborate with the third party, always a challenging and negotiate what is the percentage of the IP ownership amongst parties. And of course, some is a contractual research. They will say, I give you all the money. So I should own all the IP. This is a very common question we will face every day. Because I pay you. And I think I only can speak for PolyU, not for the other university, because that would be a different consideration in different universities. So it's always think, how substantial the financial contributions, and what is the intellectual contributions for the, or funding requirements, and during the creation of the IP. And whether, they put they will say, I put all the data in the Excel table, then I should enjoy a portion of the IP ownership. So we have to be careful. When you're working with the partners, that we have to be clear about the IP ownership. What is the role for each researcher, and what is the deliverable, whether there is a intellectual contribution. So we always remind our researchers to sign the IMA, Invention Management Agreement, before we start the projects. So they will define the IP ownership. We will define who is the leading parties for patent administration, because when you file the patent, then you're starting have an expenses consumption. File the patents, who is going to design which jurisdiction to file the patents, and what is the right, commercial right, or they have all the commercial rights, reserve the non-commercial rights for the universities. And another one is very, very common, because we work with different researchers with different universities. And some, the researchers, they say, okay, I can give up the ownership, because they think they have ownership, but in fact they are not, because they're employed by the university. Say, okay, I can give up the ownership. PolyU, you own 100% of ownership, but I want to be a share of the benefit, to recipient. Whether they can do that. Actually, they cannot do that, because they do not have an ownership, because they are under the employment. So whether the people to collaborate with, they have the right to say, they disclaim, they give up the ownership in exchange of the benefit. We have to be careful on that. We're facing a lot of that kind of questions during our practice. And inventorship, of course, that would be easier. Well, we are mostly, if you work in the universities, the researchers is an inventor. It's not the owner of the patents. So the inventor rights should be being acknowledged in the patent certificate, and also depends on the local government's policy and the policy in different universities. The inventor may enjoy a portion of the percentage of the benefit sharing. So that's, again, in different universities, there will be a different policy and regulations. So the patentability, I think some of the previous speakers, they also mentioned. We cannot file something is a natural phenomenon, but also, and also we have to think about it, what is the patentable? Novel, inventive, not obvious. This is difficult. So, for example, you cannot file the wheel is around, that already happened already. So the novelty is quite easy to determine whether this is a different than the existing prior art. And non-obvious is quite different, that it has to be determined by some skilled in the field. That, of course, that will become the negotiation between the inventor and the Patent Trademark Office. So we have to negotiate. This is non-obvious. This is a novel. That is the reason you can, to have a patentability. Of course, the patent matter subject should be useful and technical matters, and have an enablement. So, and this apply for all field of the technologies, process, machine, and composition. And some is to have a contrary to public or monetary that cannot be patent. So another things I want to also here mention is for the young researchers, they may not be very key on the terminology. Is a background IP, foreground IP, sideground IP, and postground IP. So these are the terminology is very common to show in the agreement with your partners. So background IP means before we collaborate, everything is already happened. So basically that is so have nothing to do with the collaboration. And usually the project IP is very important. So we always say, what is the IP generated in the projects? And postground is that you have the right, do you have a further right to further develop based on the project IP? The sideground IP is the other parties develop. So we have to be careful when you want to develop products, what kind of IP will be involved in this? So if you develop products, so not only the project IP, but you also involve the background IP. So then if the background IP belongs to the university, then you have to secure the license from the university in order to, you have a complete set of the IP for your commercializations. And different IP could be a different owners. So this is a very important areas, especially for young researchers, they may not, key on that. And discovery and invention process come up with the new idea, whether it's a variable. We always encounter, say, oh, I have this idea. Very great. I just published a research paper, a very high-rank research paper. But when you come to my office, then we always say, are you solving a problem? What kind of solutions? With this, it's very common mistake. Is there the need exists? And whether this is a very easy, can be fixed by the other alternative. And whether this have a strong research element. And sometimes it's always waiting for the perfect idea, so the delay of the invention process. So this is very seldom, I think it's very seldom the people will talk about it. So what is the value of your solution? So the value of the solution, it depends on 4 points. Basically, these 4 points is summarized from my experience. So how severe the problems, how frequent the problem happens, and how the problem obvious, and how expensive. So that, why is the technology related to the biotechnology so valuable? Because it's solving a very severe problem. It's about your life, about the human well-being. Because as a university, we handle different aspect of the technologies, and something is something is solving the problem is just not severe, and the user will say, so what? And obvious, so how frequent, I think is very easy to understand. How obvious mean whether you can communicate that pain point to the consumer. You're solving the problem, and the user may think, I don't feel that. I don't care on that. So this is not. So how easy to communicate? Because if you cannot communicate in a very simple way, then your cost will be very expensive for marketing. And also, this is very sellable features. It's a sellable feature. So I give an example. So one of the startups actually they make an antimicrobial technology for furnitures, and that startup they try to sell that technologies to a public bus company. Would you think it's successful? It's very, very obvious. It seems very logical because every day, a couple millions of the passengers taking public bus. But however, it's not severe for the customers, so the public bus company, because they're losing money. That's not their pain point, because their business is shrinking because the share is taken by MTL. It's not their pain point, so it's very, very logical. You think you're solving the problem, but in the end, it's failed to commercialize because the pain point we have to fulfill on the user and the customer or the one who purchased your products. And before we're talking about this, actually, during the interview when I hire a patent expertise, one question I always ask, and I think it's very difficult to answer the question. A very simple question: what is the good patent? What is the good patent? So it's like Professor Low, so many barriers. Yes, but I think majority of the occasions, what you think is already many people thought about it, that become your product. So it's very, very hard to file groundbreaking, no one thought about it ideas. Then you can file very, very broad scope of the patents. Very, very difficult. So we always use this principle, MEMC, so MISI. MISI is not invented by me, it's invented by McKinsey. So I just, when you do things, actually many ways to do it. I will have an example to explain this. I think this is very important. And I think Dr. Ricky, you said you will have to find a good patent attorney. So I bet you not many patent attorneys understand this. So during the invention disclosure process, and how your invention can be a good protected, then it depends on the communication or the experience of the patent attorneys. You are the inventor, you know the best of the technologies, but they may not be the patent attorneys. So the discussion during the patent attorney and you is very important, and how to discover the best protection of the patent. So in one case, I associated, they say, one of the professors say, I have the patent, but actually all the patent content were written by me. So I bet you this is a very bad patent quality. So we use a MISI means to expand all the possibilities. It's no matter, especially for engineering, sometimes you don't need to prove it works. It's just write down of the patents. So you have, for a human being, it's only female and male. That's all. We don't have another gender. But when you do things, always have many ways to do it. So I give you an example. It's a real example for myself, When you do a heat transfer, there's only 3 ways, no the other ways. So I think the professors invent the lithium batteries. He is the Nobel laureate, so I think we cannot file, we invent the lithium batteries. But when you use the lithium batteries, there is a inherent phenomenon, they will get heat. So heat dissipation become a inevitable path, a critical path when you implement the technology. So during that conduction, convention, and radiation, that basic thesis, what is the technology you can provide? And why you don't include in your patents? Or you include your patent, it's so expensive, you can even to disclose that. Nobody can file the patent after you. So this is we use always to make a broad scope of the patents to ensure the quality of the patents. At least we should have this discussion between the inventor and the patent attorney. And this is another example. How we can expand all the patent portfolio can be commercialized. This is one example, I think, during the time when Professor Tong still, you were our president in PolyU. It is a very good case. It's a myopia control technologies. So as you know, all the children, they start to develop their eyeballs starting from 6 years old. And very easy to get myopia. I think the prevalence of the myopia problem is very high in Asians. And especially when we found during COVID, because we couldn't go out, the children always look at the electronic device, they even get higher. So we create a different pattern portfolio for this myopia control. We have the DIS and DIMS. Basically, just like what I said, we could have a defocus technology is the technology principle, but we can have a different approach to achieve that objective. We found different patterns, and then we solve the issue. And usually, the commercial company will say, oh, I want to have an exclusive deal of the license, because I pay you money. I pay you that much money. Kelvin, how much you want, you tell me. I want an exclusive license. I want to protect my commercial benefit. So in this one, yes, I give you exclusive license on one patent, but also we have another patent. So we could expand our portfolio from a university perspective. It's not making money. This is not the first priority. It's a benefit of society. It's our first mission. So we license the technologies to different big companies, but also including the academic-led startup. So that was a very successful case, and we're selling a lot of the myopia control lens. So I want to use this case to illustrate. Sometimes you can think about more and more different potential approach when you're doing your research projects. So you never know, you can license to the others, or you can also to start your own company. So give you more possibilities. So the consideration, I use this mountain. The good pattern is when you go up to the top of the mountain, there are many, many ways. Which one is the shortest and the lowest cost and is the more benefit to you? And this is we call it an inevitable path. So we have to challenge ourselves, what is the inevitable path? If I want to do that, we must have that problem. And of course, to distinguish with power art, so this is very important to understand your priority day. Before your priority days, everything is power art. So because of the, I think, financial restraint in the university, it's very hard to have a very comprehensive power art search before filing. We will do it in parallel. And also the time is very, very close. It's something we're always focusing on encountering the urgent filing, the US provisional patent. So study power art, especially if you are the expert in this area, you should know that. A minimum system definition, what that means. So we don't file a patent with for a table with 4 legs. We file a patent with a table with 3 legs or above. So what is the minimum element can make the system run? And the other thing is just, you can put a cam 2, cam 3, cam 4. So what is the more things you cannot missing? Define dependence, whether the technologies have a dependency with other technologies, and prioritize your broad protections. Whether you want to separate the cams or you separate to file different patents, you don't need to put all the things in one patent, because if you will be invaded by your competitors, that is very dangerous. And this number 6 is very interesting. If you have very, very critical invention, in my past experience, we always form 2 teams. We use the other team to crack our original invention, to let them compete, to make it your invention more compete. Because always you have your bias to your invention. You're better to have someone to try to crack your invention and include that in your patents. And jurisdictions. Of course, I think some of the jurisdictions is very expensive, like Japan is expensive. Europe is also expensive. So how we determine the jurisdiction for application? That it depends, I think, what do you want with your patents? Whether you want to practice your patent, you want to commercialize, or you want to sell to license to the others. So some of the consideration you can take a reference, market size, legal framework, because some area you can never enforce your right. Cost of patent filing, competitor presence. When we encounter the big companies, you also cannot file all the countries around all your competitors. So you should select their major market and their headquarters. And license and transfer potential, whether you want to license or you don't want to practice your patents, you want to license, then you can select this jurisdiction. So these are the considerations we will discuss with the inventor, so when they select the jurisdiction. And again, this one is also very important. When we're doing invention, we associate with technologies. So we have to understand what level of the technologies. Platform technologies, core technologies, main technologies, and auxiliary technologies. Platform technologies means you can share with all the different kind of products. That is a very core foundation of everything. And core means to make a function work, and some main is a good, to have a competitive, to compete with your competitors. Auxiliaries means you can have it, nice to have it, something like that. So that will be done on different market segment. So in different market segment, you have a different rating of the portion of the technologies. Then you can determine how much I should spend on the patent. Because some segment, you do it for profit. And some segment, you don't make money. It's just for branding. So that can give you a market perspective and technology perspective and how much you should invest on the patent filing. And that will be changed from the time, not always the same, so you have to review that. And important notes for patent filing. So as a recap, so ownership, inventorship, we have to manage carefully what is the right and the role, and confidentiality pre-filing. Please don't, if you want to file the patent, don't disclose in the public. Trade secret on the patent, strategic filing considerations. So what is the purpose and where we should filing, what is the invention in the context to understand all the landscape and your patent uniqueness, patent due diligence, and sometimes it's just expired. So I'm not sure, have you do the due diligence, some patent is already expired, or someone has not paid the patent fee. So it becomes free to use for public, and portfolio management. So this is all my sharing. I hope you can enjoy, and so we can have more discussion during the networking. Thank you.
Thank you, Mr. Wong. We'll invite you again for the panel session later on. And without further ado, let's welcome on stage our fourth speaker, Ms. Jennifer Chiu, President and Managing Director of Eagle IP, to share with us on smart IP strategies for protecting your innovations. Over to you, Ms. Chiu.
Thank you so much. Wow. There's been some really amazing talks and lots of content, really, really rich content. I almost wonder if my talk is a little too simple for you guys. So I might kind of wing it a little bit here. I'm going to skip some stuff because I think some of these guys have already talked about it. But all right, let me see if I can get this. Oops, is it the green one? Oh, sorry, it's this one. Okay, got it. All right, so let me introduce myself. My name is Jennifer Chiu. Maybe you can tell from my accent, I am actually from the United States. My parents are from Taiwan. I moved here 7 years ago, so but I will try. So so a little bit about my background. Actually, I was a scientist as well. I studied chemistry at MIT, and I worked as a research scientist, as a medicinal chemist at Millennium Pharmaceuticals for about 6 years before I switched careers and switched into patent law. And then I worked at Vertex Pharmaceuticals as a patent agent and then eventually a patent attorney. I actually went to school at night at Suffolk University in Boston. And worked at Vertex for about 10 years, handling multiple patent portfolios, so really pharma, biotech background. And then I went into the startup world, so big pharma and then small startup. Excella is a Flagship-founded startup. Flagship is also the founder behind Moderna, just to give you a sense of this incubator-type investor VC fund. So I worked at one of their baby companies and built up that patent portfolio for about a couple years at that startup before IPO, and then moved out here to Hong Kong 7 years ago. So ever since then, I've been at Eagle IP. We're a boutique patent firm. We're here based in Hong Kong. We also have a office and agency in China, so we file directly in China as well. But I'm personally a U.S. patent attorney, so I'll share a lot kind of from both a U.S. and a China perspective. That's kind of my general background, but of course, have done a lot of global patent strategies at a big pharma as well. So, okay, I want to start maybe just a little bit about I think a lot of people don't understand patents, and we've heard from a lot of people who really do understand patents, but you see a lot of media, they say things like, Apple patents a paper bag. Did you know that? Do you know this is patented? Apple patents a paper bag, bold new innovation. Apple patents a pizza box. Oh my gosh, have you guys seen these Apple pizza boxes around? And this question about who owns the coronavirus cure, this was a couple years ago. China moves to patent Gilead's experimental drug. How can that be? So a lot of confusion in the media about patents. Like, what is a patent? So for fun, I decided to go to the US Patent Office and take a look at this pizza box to see like what was actually going on. And I went to the US Patent, you can see that's what the file looks like. And you can see that, abandoned. Whoops, let me go back. Final rejection, abandoned. Apple did not patent a pizza box. Apple filed for a patent application on a pizza box that was published, and a lot of people see a patent publication and they get confused and they're like, oh no, there's a patent. No, it's just a patent publication. It has absolutely no rights. And it got abandoned. It was rejected, okay? But let's check out the paper bag. The paper bag was actually patented. You can see the application on the left. So that's what a publication looks like. You can see the patent on the right. If you look closely, you'll notice that Apple had to narrow the claims a bit, and they had to kind of include this handle. So by the way, this handle is actually sustainable. It's made out of like paper. So that's kind of part of its innovation. And also, because it was a white bag and it was at least 60% recycled material, supposedly, I guess it's really hard for it to be strong. So they were able to find a way to bleach it and keep it really strong. So that's why they got a patent. So again, this just highlights sort of the knowledge about patents that the media doesn't even understand. They're confusing the pizza box with the patent itself, right? But we're here. Oops, yeah, so let me just move that one. All right, so I'm going to skip this because we've already talked about, I think, previously what a patent is. It really is a two-way street, right? You have to disclose, and in exchange, you get a 20-year exclusivity. And I think one thing a lot of people get confused about is that a patent only gives you the right to stop others. It does not give you the right to practice. And I think, I think Ricky maybe mentioned a lot about FTO, right? Because freedom to operate is a different, and I think, freedom to operate means that, you can actually practice. Getting a patent never means that you have the right to practice your own invention. People can file patents on top of each other, like the platform technology, and then the later developments and improvements. That CRISPR patent, the grandfather of CRISPR, is still gonna stop you, and you might still have to get a license from that CRISPR father patent, even if you've invented on top of that, right? So just to remember that a patent only gives you the right to exclude others, and you still have to clear yourself. And it's a certain period, and it's a certain jurisdiction, right? We've already talked about that. So I will skip this. We talked about novelty and inventiveness. We'll skip that. The claims are the most important part of the patent. It defines the walls, and that is a very nuanced type of language, and I would not trust a person who has no patent knowledge to write your own claims, because claim language is very, very specific. But essentially, the claim defines the boundary, and to find infringement, you have to find each and every element. And this is why, the minimal number of elements you can put is actually the best and broadest type of claim. Because if you file, something that's too broad is going to be considered not novel, right? The prior art is already going to fall within the scope of your claims. If you want to get something that's very narrow, well, that's great. You can get the patent, but then your competitors are going to, copy and make design arounds, right? So of course, the best type of patent claim to draft is one that it just draws yourself around every the working scope of your invention, covers your competitors, but avoids the prior art. Easier said than done, but that is the goal of every patent attorney when they're talking with you, when they're having that discussion with you. They want to understand the competition, understand what's already out there, understand the scope of what actually works, and your goal is to draft that exact circle. Okay, so let's talk about a hypothetical story. All right, there's a professor. We'll just call her Professor, I don't know, H, whatever, professor. A professor is in Hong Kong, and the year is 2020. And there's a pandemic going on. So what happens is this professor happens to go to Shenzhen and gets stuck there because it's the pandemic and the borders are closed. The professor has a lab, and so she's actually stuck there for 3 months. But she has her lab in Hong Kong because she's a Hong Kong professor. She continues working with her graduate students, advises on the experiments, analyzes the data, and Zoom is exploding at this time, so it's very easy to use. And professor is guiding the direction of the R&D with her graduate students. And a lot of really good research actually happens during that time. The invention gets gets them complete. The professor is still stuck in Shenzhen. So they're like, oh, we've completed the invention. And actually, they meet someone who's really interested and kind of wants to buy a prototype. So she's like, okay, let's just sell this, a private sale, just do like a friend, really. They sold a few working models of the invention. After that, professor comes back to Hong Kong. Soon after, they decide to publish on the results of this invention. So there's an academic publication. That's great. It gets published. And then after that, the professor realizes that maybe she should file an application. So she, contacts the tech transfer department, and they file a US provisional. And the professor is listed as the only inventor on that application. 12 months later, they file a PCT, which is a global application, and at the 12-month date. And and over time, the product launches, they do a startup, things go really, really well. The PCT goes global, and we talked about picking different countries, and they file in a number of different countries, and those patents slowly get granted. And then IPO, the company is doing so well at this point, now they've got investments of millions and millions and millions of dollars. And they're starting to sell their product, and things are going great. And then a competitor comes along and challenges the patents. And the Chinese and the US patent have both been invalidated. What happened? What went wrong? So let me talk about some issues and common mistakes that people make that could cause something like this to happen. All right, we talked about novelty, right? What is a novelty destroying act? Of course, we talked about publications, right? For example, your invention has to be new. Therefore, a publication that happens before your filing could destroy the novelty of your patent. This could be a pitch competition where you've disclosed a little bit too much and you didn't, you disclosed before you filed for a patent application. Maybe you just told your friend about it and the friend didn't sign an NDA, so then somehow the friend put it on Facebook or something like that and it becomes public. An act of a sale is actually a novelty-destroying event. The patent government doesn't want you to just be making money for years and years and years and then file. Interestingly, in China, the sale has to be public. In the US, it can be a private sale. So novelty itself, these are kind of potential issues that could come up. So what about obviousness, right? Obviousness, we talked about the concept of that. What happens with academic publications? The way they're often written is that they're written like this. Oh, we are in this field, so-and-so professor, Professor Lo, and then Professor Ricky Chiu has published on this, and we thought that the rational next step after seeing in the field, of diagnostics, that this should be the next thing to do. So we tried it, and we have confirmed that this is exactly what has been done, and therefore, we have confirmed it, and this is great. This is how academic publications are written. Unfortunately, it sounds like when you write it that way, you're just saying it's pretty obvious, because Ricky has already said it should be done, Professor Lo has talked about that, and now you've just said that you did it, right? The examiner at the patent office is gonna say, what's your innovation, right? We don't want to talk that way. Instead, we want to make it look like, or at least we present our case to say it is an obvious, unexpected result, we've got surprising data, and this is groundbreaking, and no one before has ever thought about it. Now, it's really hard to write an academic publication and not honor your elders, right? Because that's the way we're supposed to write. So how do you do that, right? So you can. There's many ways to do it. Instead of, writing about your data in a way that makes it look like it's a certain position, just be factual, right? Write the facts. And that way, if you're writing it in this, without kind of showing a certain direction, then later on, if you need to, you could decide kind of what position you need to take with respect to your data. So in general, you want to write your applications, you want to avoid certain words such as reasonably expect, or we predict, or as obviously as we showed before, consistent with what we have done before. When you say that, you make it sound like your invention is obvious. Instead, really focus on your unexpected unexpected findings. You can say, surprisingly, this was, the result. It was 3 times as good as anyone thought. We are so amazing. We are so inventive. Ideally, you would coordinate your IP strategy together with your publication, and they would be consistent. I have a very sad story. I'll quickly share it. This is a famous case from about 20 years ago. 2 huge giants, cancer. This is cancer drug. It's Taxol, actually. So what happened was the patent agent drafted an application based on a JAX paper. But if you look at the language, the JAX paper said that certain protecting groups are actually unstable and did not work. the patent application said preferably R3 can be this, preferably R3 can be that. And it said all of these protecting groups were part of the invention. Later on, the key is that they didn't tell the patent office about the paper. They didn't cite it. And then later on, the patent gets granted. Nobody knows about this paper until it gets invalidated. It gets challenged by I can't say the name, the other big pharma company. And essentially, the patent was ruled invalid due to inequitable conduct. They're like, you were the person drafting the application. How could you say you did not know that this paper existed? You wrote your application based on the paper, and you didn't tell the patent office about it. You lied. You committed fraud on the patent office. So, this is an extreme case, but you might see this in an FDA, right? A drug company wants to tell the FDA that our product is safe. It is very similar to the previous types of compounds, that were out there. Therefore, the PK profiles are equivalent, so we're safe. We don't need to run these clinical trials. At the same time, that previous compound is now, you just said that you were the same as it, but from a patent perspective, you're telling the patent office, oh, we're completely different from that previous compound. You're just giving inconsistent statements. And maybe it could be, maybe not as bad as this, but they might be called into question. So for obviousness, you really have to think about what you're saying and what position you're saying, because it could really impact your arguments for whether your invention is inventive. We've talked a lot about patent filing strategy, about the timing of it, so I'll just skip this part in terms of the common mistakes. Another interesting aspect I want to talk about is security clearance issues, right? Excuse me. Different countries have different rules, and certain countries, like the US and China, are very, very, very protective about the IP that's arising within their territories. So both China and the US have a rule. They say, if you invent something in my territory, you cannot file a patent application somewhere else first. You must ask me for permission, just in case there's a national security risk, and I will approve it, then you can file somewhere else, right? Interestingly, Macau and Hong Kong, or maybe thankfully, Macau and Hong Kong do not have such rules. So if you're in Hong Kong and you invent in Hong Kong, you can file that US provisional first. But if you're in China and you invent something, you cannot file that US provisional first. You will be violating China's national security law. And similarly, in the US, you cannot do the same thing. If you do, your patent is invalid, and you can never get a patent in that country. So that's really important. And the thing is, the standard might even be like, well, what does it mean to be invented in a place, right? The US has very well-established inventorship rules that tell you this is what an inventor is. China's a little vague. It says, if the invention were completed in China, you're like, shoot, what does that mean? If I had a researcher making it, was he the inventor, was he not? Does that count as completed? Now do I need to ask for permission? We're in the Greater Bay Area. We've got lots of collaboration going on between mainland China and Hong Kong for sure, maybe even in the US, right? So what happens? Wait, let me see if I have the slide. We talked about ownership, right? Oh, let me just see. I'll go back a bit. So what happens when you're collaborating, right? You've got this issue of where do we file first? Do we file the US provisional, or do we file in China, or do we file in Hong Kong, or what? That's the first question. But not only that, you've got ownership issues, right? And we talked a little bit about that earlier, right? But ownership is messy because different laws in different countries, right? We talked about the employment rule, but that's only in China and Hong Kong. That employment rule doesn't apply in the US. In the US, the inventor is the owner. And you have to have an employment agreement, and the agreement has to say that the company owns it. So it's much more open in the US because the inventor is more likely to be the owner. In China, if you're working for a company, in Hong Kong, if you're working for a company, those rules might apply. Now imagine that you're collaborating, right? Between, let's say, a Hong Kong company and a Shenzhen R&D site and a US professor, and you're all talking on Zoom. Oh my gosh, where do you file first? Who owns the patent? What's gonna happen afterwards, right? It's a big mess. So you really have to get those agreements signed beforehand to work this thing out, because if you have to depend on the law, lots of money, lawsuits, litigation, like Professor Dennis Lowe said, you don't want to spend money on lawyers, right? It's not worth it. Litigation, I should say. Figure the stuff out first and make decisions, right? Because it gets really, really messy. And finally, I appreciate what Ricky said about investing in IP. IP is important. It's not everything. You have to invest in R&D. Obviously, if you have no inventions to protect, then there's no point in filing for patents, obviously. But you shouldn't also just put it off till it's too late. There's timelines for these things, right? We talked about that. If you don't file until it's too late, then you have nothing to protect. Usually people spend more money correcting mistakes they made from a bad patent strategy first than maybe they could have if they had just invested a little bit more upfront. So definitely set up a budget, 5, 10, 20, whatever, % of your R&D budget, and keep it aside and invest in your IP from the very beginning. I would say at least get a strategy, because the worst is not to know and not to spend a little bit of money on the consultation just to know what risks you can or cannot take. I think that's really important. So finally, just on a side note, this is a little bit unrelated to everything else I've said, but there is a lot of confusion about what is a patent attorney and what is a patent agent and what is a patent lawyer and what is all this stuff. So let me just clarify a little bit so you understand. What makes it confusing is that different countries use different terms. So in places like Europe, the UK, China, a patent attorney is a person with a scientific background who then goes and takes a certain set of exams. They get qualified as a patent attorney, and then they can practice before the patent office. A lawyer is not a patent attorney. A lawyer goes to law school. A lawyer has no technical degree. A lawyer becomes a solicitor or a barrister, and they can represent you in court. A lawyer coming to you and say, I can file patents for you. Right now in Hong Kong, there are no rules about that, so anybody can file a patent for you in Hong Kong. But essentially, lawyers and patent attorneys are different. What makes this confusing is that if you meet a US person like myself, is that in US, if you have the technical background and you take the exam, you become what's called a patent agent. And essentially, it's like a patent attorney in these other countries. In the US, in order to be qualified as a patent attorney, you have to go to law school and get a JD. And then you have to be, state bar qualified. So I happen to have both, which is why I call myself a patent attorney, because I went to law school, I'm a JD, I'm a lawyer, and I'm also a patent agent. But in China and in the UK and in all these other countries, you don't have to go to law school to be a patent attorney. So I just wanted to clarify that. I think no matter what, as long as you find someone that has the right technical background and the qualifications to be a patent agent for you, patent agent / patent attorney, that's okay. I would say if it's a lawyer, you better just at least check to see if the lawyer actually has technical background. So let's go back to our story. Curious, who wants to give a suggestion for what might have gone wrong in our little scenario? Why did those patents get invalidated? Yes, Professor.
According to the export control, they should have filed in China first.
Yes. Yeah. Yes, exactly. They should have filed. Well, so there's a few things that you're right that if Dr. Lim, I guess I had a name for her. If Dr. Lim had truly been the only inventor in China, then yes, they should have filed in China first. There were other graduate students, so there is an open question about whether there are other, inventors as well. So in that case, maybe they, maybe who knows, but correct. So there I have, if they had filed in China before the private sale, before the academic publication first, then they could have saved their patents. Thank you guys so much for your time and energy. And this is my ways to contact me if you want to get involved. Thank you.
Thank you. Thank you so much, Ms. Chiu, for the presentation. A lot of insights and a lot of important information for us to know about as well. The four speakers actually enlighten us with a lot of examples, their personal experiences, to tell us how patent application would be important for our scientific innovation. Well, I'm helping us to keep the time for now. So just before we go into the Q&A session, just a show of hands. Who already have questions in your minds that you'd like to ask? And we'll open the floor immediately, all right? So have your questions ready, have your hands ready. We're going to make sure our mic runners will go to you and you can raise your question right away. And now I know our stage is ready, and why don't we welcome our four speakers to the stage. Please welcome again to the stage our four speakers, including Dr. Chiu, Professor Lo, Mr. Wong, and Ms. Chiu. Let's welcome them. To be honest, the questions that I've prepared, many of them have already been answered because your presentations are really detailed. So we go straight ahead to the Q&A session. I know there's a gentleman right there with a question. Would you please bring the mic over to him, and then we'll have the first question. Let us know which speaker would you want the question to be answered.
Sure, thank you. By the way, my name is Francesco. And very appreciate all of you, like speakers, that we learn a lot. That my question is to Dr. Chiu. May I ask now or not?
Yeah, please.
So Chiu, about that, you mentioned about you successfully negotiate an agreement with your alma mater onto out of the IP of your doctoral thesis. Right? I have particular interest onto that because I myself also deposit my doctoral thesis into PolyU. You know, that day, I only getting out a physical piece of diploma from President Timothy Tong. Thank you, Professor. And that's it. But now, okay, see, well, how would that be a reasonable expectation out of the whole negotiation by the end that I could get off as an agreement, right? Would you mind share with us a little more on that? Thank you.
So first, I think there's a much better person to answer this question, especially coming from PolyU. But I think, well, sharing my own experience is the fact that I was still with UCLA while I negotiate with UCLA, and I formed the startup while I was still at UCLA. So I think things go pretty naturally for me. Just go to the tech transfer office and explain to them that I have an intention. Right? I mean, they actually have a LOI, letter of intent, to officially tell them that you are interested in licensing the technology. That I'm the inventor, but I'm not the owner. Right? Thanks, Jennifer. Right? I'm not the owner of the patent, and in fact, I would like to go into the negotiation, and then the tech transfer office then would have with a case agent then start negotiating with us. I mean. It is not a smooth sale, right? It does go back and forth a couple of times. I did need to, negotiate on the royalties, on the upfront cash, on the milestone payment. These are the couple of things that are essential, part of the journey. Obviously, for me, I'm cheap, right? I want to make sure that I pay the least amount of, of things possible, and the university want to keep a fair balance, right? And but it is a negotiation process that you have to go through. I don't think this is major difference whether you are still at the university or you have already graduated. I think universities should welcome anyone that have interest to the patent that are being generated. Of course, you coming from your alma mater would certainly play certain roles in terms of favor of negotiating that, because and especially while you are also the inventor of it, I do believe the tech transfer office would also have preferences preferring investor to license the technology. I think this is a very strong incentive to encourage anyone to file patent and do research, right? So, but I think for your cases, I think they are much better, someone that can answer your question. Yeah.
Mr. Wong, would you like to add to that?
Yeah, I think during the recent 2 years, so we have done a lot of the changes. So right now we license back to our PolyU IP, back to especially for the startups. So we have a very friendly policy. For example, we offer a trial license, 5,000 for 1 year and 10,000 for 2 years, then without any charges, royalties. So and also we keep a very low license fee and royalties. So I think for you, one thing is about the license fee, but I think it's more important, just like what I said, we have to understand the core of the technologies, whether this is a platform or a core technology or series technologies, and then you can decide whether you want to secure an exclusive license or a non-exclusive license, or in different territories, where all these parameters will affect the license fee. But you can consider that after 2 years trial license. So we offer a period of time that you to trial the technologies, whether have a market value, whether this is a really workable, for a commercial world, and then we can, to enter the real license term. So, and I can guarantee you, no worry about it, because university, again, is not for the commercial purpose. I think it's the reasonable, reward back for the inventor is the key. And recently, we really support our startups, so don't worry about the fee. And I think catching up the opportunity for the innovation and entrepreneurship is more important.
Thank you, Mr. Wong. Francesco, stay with us for the networking session where you can talk more with Mr. Wong later on. Okay, I know we have a lady over there with a question as well, so would our colleagues please bring a mic over to her?
Thank you, Dr. Ricky, Professor Low. I was a graduate from CUHK, so I have attended your talks many years ago. And after so many years, when I am already an entrepreneur here, I have learned different things from you today. And I have a question for Dr. Ricky and Ms. Jennifer. So, how to find a good how to formulate a strategy to find a good attorney. In my case, my invention was should be applied in the food industry. Usually, food industry they seldomly file patent. They only keep it as a trade secret. So it's very difficult for me to find a good attorney to have a knowledge of the industry. And my experience is, before I find the attorney, I need to pay like 1 hour for 4,000 to an attorney, and I introduce my technology, I introduce the food industry, I teach him a lot, and then I pay 4,000 for her. And then I thought, okay, this guy doesn't know anything for food industry. So what's your suggestion for a good strategy to find a proper attorney? Yeah.
Maybe I start first and then go to Jennifer, right? Again, I can only speak from my own experience, but I think my understanding about patent, it came from my mentor. And my mentor he obviously have vast experience in filing IPs and all that. So I think a lot of so-called common sense, or something that is not so common for me while I start the company, came from my mentor, able to explain to me how this world works, right? And I think it is important because you don't want to jump right to a lawyer and start paying hourly fee to learn all that, right? I mean, lawyers are expensive, but they're essential. So you want only to pay them to do the exact stuff that you need them to do. Mentoring you or educating you is not part of it's not part of the scope that you want to pay very expensively for. So I think, especially right now in Hong Kong, I think the ecosystem is getting better and better, and I think university also have a lot of resources to hire very experienced folks to able to consult, startups. So I do think there are free, resources for you to upgrade your knowledge in the field of, intellectual properties, and then also get very good advice, and then, and in the process would also allow you to find, from the word of mouth, from referral, from experience from others, that you're able to get, good patent lawyers that in your area, in your field, that you can start to trust and use. And I'm sure Jennifer have more to add.
Thank you. Yeah, I understand your pain. Technology is something you want to make sure that the person. I think you're talking about two different things, right? There's understanding the technology, which is really important. Maybe you can do that through looking at the educational backgrounds of the patent attorneys. But I think what your pain point is sort of on the business side, right? Because if you're in the food industry, you want to have a patent strategy that's thinking about the product, kind of like whether to do a trade secret, whether to keep the manufacturing private, what happens in the food industry. And that is really hard, right? So I think if I were in your shoes and I had to do that, I would do a search, I'm in the patent scope, just to see who's filing on this field, right? Go to the big ag or the big Kellogg's, I don't know, pick your competitor or like a LaSalle, and see who they're using, just to get a sense of what these patent attorneys are like and where they are. Maybe Hong Kong doesn't have any, and maybe you just have to find a related industry that at least has some of the same challenges. But otherwise, yeah, it's a trust relationship, so you kind of have to trust the person. I mean, patent attorneys have to make money, so they have to charge for their time to some extent, but you want to hire them to look at your specific situation to give you tailored advice. That is worth it, right? It's not worth it for you to be teaching them about your technology for the whole hour, right? That doesn't make any sense. So it is a tricky balance, though, because at the end of the day, you guys are innovators, so what you are inventing does not exist sometimes. There is an aspect of explaining, because you're literally breaking ground in a new area, right? So that has to be part of it, but But if it's because they don't know the background of your field, that's a little bit different. So there's a balance there, I think, that you have to find. So no quick answer for you, unfortunately, but good luck. Yeah.
Thank you.
Thank you, Ms. Chey, and
Very
do your
useful.
research. That will help you. Okay, before the next question, I actually have one question that we would like to direct to our distinguished speaker, Professor Lo. It's really an honor to have you here today. So on behalf of the future, leaders or amazing scientists here, how do you see the future trends of actually intellectual property influencing scientific innovation? Do you have any views on that, about the future trends?
So I think I've worked in Hong Kong now for 28 years. I think that the Hong Kong scientific community is actually getting more and more aware of the importance of IP. When I first came back, very few people find IPs, and very few people have their startup. But now, actually, this trend is completely different. And of course, now you have sessions like this. So I'm generally very optimistic. But of course, there are new developments, like since 2019 December, Hong Kong started to examine its own patents. So this is a new thing, right? And now, of course, you have this thing called a patent box, in which they give you a tax reduction if you have an IP file in Hong Kong. I think if you're starting a business, then you really have to start thinking about that as well. Yeah.
So start thinking about that early and plan early. Thank you, Professor Lo. I know we have another question in the audience. Yes.
Hello, thanks for insightful sharing. I really learned a lot in patents. So I'm from CTU, I'm a year 3 student, so I have a question. So I noticed that Professor Dennis Luo has a collaboration with Illumina, a sequencing company. So in China, there's also another sequencing company called BGI Genomics, Huadajin. So in overseas countries, Illumina has brought many troubles, many lawsuits to BGI Genomics. And so recently, Chinese government has restricted Illumina for its sales or other operation in China. So how do you think we can protect our patents better under these geopolitical circumstances? Thank you.
Who would you like the answer to be answered?
Maybe Professor Lo or any other who wants to add. Thank you.
Okay, all right.
I think the situation with Illumina, of course, we are observing very carefully, because Illumina is one of our licensee. I still don't know actually what is the impact on that, Of course, if you look at the Illumina share price has dropped precipitously. So I think, of course, in terms of filing patent jurisdiction, I think we can only, as scientists and innovators, we can only still cover those jurisdictions. But we have to bear in mind that probably in the future, say merger and acquisition might be more complicated to go through, right? You have stuff like CFIUS and all this thing. So, yeah, so I think we protect and then think about that later. Because if you don't protect first, you don't even have a chance to think. Thank you.
Make sure you're well protected. Yes, Professor Tong?
Well, thank you to all the speakers for such sharing with all of us. I think it's extremely informative. The insights you share, I think, allow us to learn a lot. I have a question for Jennifer, actually, because based on what you described of your background, I'm still wondering, what brought you to Hong Kong? Right? You could have, practiced in the States.
Yeah, there's a short answer, I guess, and yeah. So essentially, the short answer is that in 2015, one day out of the blue, actually my husband got a call, and then a recruiter asked him if he wanted to move to China. And then it was out of the blue because we're both ABC, so we're Asian, both of our parents are from Taiwan. So, but honestly, he doesn't even speak Chinese. And myself, I can speak Mandarin, but again, we never thought about moving here. But a number of really kind of interesting things happened through kind of a 1 to 2 year process that made us decide that we would come. And it was just a bunch of kind of unusual events that almost seemed like, that we were kind of meant to come to Hong Kong, And the interesting thing was we came in 2017, right before a lot of things started happening in Hong Kong. So I find it to be kind of interesting that Yeah, it's another long story that I can share sometime, but it involves interesting things like somebody even dreamed about it, that we were moving to China. And eventually, actually, he was supposed to be in Shenzhen, but then again, a number of things happened and it ended up being in Hong Kong. And I really thought I was gonna just give up my career because I thought Hong Kong doesn't have innovation. You know, I thought it was a banking finance center, and I thought, you know what, I'll come here and maybe I'll be a professor or I'll just teach a course or something. And interestingly, I met Jacqueline Loy, who's the founder of Eagle IP, and then she had actually been praying for someone, like a US patent attorney, to kind of thinking about succession planning. And we met up and we both had kind of life science backgrounds, and who would have known that back then, coming here as a US patent attorney, that Hong Kong would start to actually develop and grow and want to invest in life science. So I just find the timing to be really interesting that, we came here not knowing what would happen. And in a lot of ways, a lot of, things happened in the history of Hong Kong. The place has changed a lot, and it's gone through challenges, and it's also gone through a lot of interesting developments. I think for innovation in life science, it's been really exciting. So I think it's really interesting to be here at this time. I didn't expect to continue practicing as a patent attorney. I didn't expect to meet Jacqueline. I really thought I was kind of giving up my career, and I was okay with that, even though it was hard. But surprisingly, I've actually become much more probably the best patent attorney I've ever been, because I've had to learn China, I've learned Hong Kong, I still maintain my US patent knowledge, but now I feel like with kind of understanding this ecosystem here, it's been really interesting. So yeah, it's a long story, and the story itself is really interesting about all the interesting signs and wonders and how we kind of knew we were supposed to come, but happy to share that another place and time.
That's wonderful. I'm glad Hong Kong has you and your family here before the government started recruiting talents.
Yeah,
right?
2017.
Now the Hong Kong government has a program to recruit special talents from abroad.
Yeah, we came before
Thank
all
you.
that.
All right, and thank you, Ms. Che, for the response as well. I think what we can draw from her story is that don't limit ourselves, just make that first step. I think that echoes with what we always encourage you for the research journey as well. Just make that first step, and you don't know who you will meet, who you connect, and make sure you make good use of the networking hour later after this session as well. So with that, I think we'll conclude the panel here. Let's put our hands together to thank all our speakers again. Thank you so much for sharing your experience and your insights, and thank you for being here. Thank you for your time. You may now proceed off stage and be seated. Thank you once again. Thank you. Ladies and gentlemen, let's give them another big round of applause. Thank you so much for all of them for their time and all the insights. Well, make sure you know the forum is now open for application until the end of March. So if you have not registered yet, please do so before the deadline. And in the following time, we are going to encourage you to stay with us because we have a networking session where you can mix and mingle with the participants here. And we hope you've enjoyed today's session. We'll see you at the forum. Thank you.